It is May 21st of 2026, and this is the Court Gallery. Today's docket is a wild ride from start to finish. We kick off with a defendant trying to convince a judge that 2 giant 20-ounce canned cocktails are just 2 drinks after blowing more than double the legal limit. Then, halfway through, another defendant's hearing is completely derailed when her estranged husband sends the court a letter that does her no favors while she's sitting in jail. And we wrap with a defendant on Zoom who decides the best legal strategy is to object to, well, everything, including stating his own name, pushing a patient judge to her absolute limit. You're not going to want to miss a second of today's cases, ladies and gentlemen, and it all starts right now.
Michigan versus Alyssa Worm, file 26-44288-SD, set for sentencing today. Do we have Ms. Worm with us?
Yes, Your Honor, I'm here.
Could you turn on your video, please?
Oh, gosh.
I've sent her a prompt to start it.
Okay, thank you.
All right, I do see Ms. Worm is with us now. This is set for sentencing. I have received a Catholic Human Services Substance Use Assessment Report. Unfortunately, I've not had a chance to review it yet. Mr. Fortier, have you had a chance to review this?
Just now, Judge, yes.
All right, give me just a minute. All right, I've had a chance to review the Catholic Human Services Substance Use Assessment Report, which was submitted by Tracy Wheeler. Ms. Worm, I'm going to give each of the lawyers an opportunity to tell me what they think I should do as a part of the sentencing. And then after you've heard what they have to say, I'm going to give you an opportunity to do the same thing. Mr. Fortier, your comments?
So, Judge, just noting that when she met with the evaluator, she indicated that she only had 2 drinks after work, which were canned cocktail drinks. Her blood alcohol in this case was a 0.173. And I think the court's very well aware that 2 drinks, regardless of if they're canned cocktails or beer or anything like that, is going to be enough to get someone to a 0.173. So I think just kind of thinking about her, any sort of potential treatment in the future, she should learn to be honest with herself, kind of about where she's at, because she is indicated in here to have a mild use disorder, and I think that's something that she hopefully should recognize and think, hey, I'm young enough to fix this. So there is a prior, but it's old. We're talking 2001, so 25 years had passed before anything else had happened. I do think the recommendations are appropriate, and that being that she remain abstinent from any drugs and alcohol. So I would ask the court order a period of probation, that she remain abstinent, that she attend self-help meetings at least 3 times a week, that she attend outpatient substance abuse counseling services and follow recommendations of her therapist, and that she also complete the Mothers Against Drunk Driving Victim Impact Panel and the Alcohol Highway Safety class. There is a $345 request for reimbursement to the Gaylord City Police Department. And I would leave the issue of jail, or not jail, work camp versus community service to the court. However, I do think that something would be appropriate, and I would suggest somewhere in the neighborhood of 15 to 20 hours, depending on which one the court's preference is.
Thank you, Mr. Fortier. Mr. Dick, allocution?
Yes, Your Honor. So, Your Honor, as Mr. Fortier said, she has not had anything happen in 25 years. Not even a single speeding ticket since the incident 25 years ago. That being said, Ms. Worm is a single mother. She does work 2 jobs. She has 2 teenagers. One is presently in college. But the recommendations were discussed, and she is agreeable to those terms. We also anticipate the period of probation, as is the court's usual MO. That being said, Your Honor, we would be in agreement with Mr. Fortier's recommendations. However, we would ask that the court considers mainly community service, if that, or work camp, and specifically an extended period to complete that, just because of her work and parental commitments. That being said, Your Honor, we would ask if the court considers or would consider possibly reducing fines and costs to allow her to continue to support her family. And that being said, we'll leave it to the court. Thank you, Your Honor.
Thank you, Mr. Dick. Ms. Worm, is there anything that you want to tell me?
And not really. I did have a conversation with Mr. Dick this morning, so we were kind of on the same page that I would be fine with that. I accept the things that I'm going to have to do, and will hopefully better myself as well. And I, appreciate still, being able to do what I have to do to support my kids, as he says, and I'm totally willing to. I've already made the changes. I know I still have to complete the Mothers Against Drunk Driving, and no, I haven't been to AA yet, but I will do all those things if I, because I have to, because I think it would be good as well, even though I just to kind of keep in that mindset to continue just not drinking and not making stupid decisions like that. And I think that's all.
All right. Mr.
Although I do-
Fortier, go ahead.
Oh, I'm
Go ahead.
sorry. I did have one question when you mentioned a reimbursement to the Gaylord City Police. I was just curious what that was about. That's the first I heard, I think, of
Yep.
this.
The statute allows for the investigating police department to ask for reimbursement for costs incurred in the investigation of the crime. And so the prosecutor asks for restitution, which is what that is. And that's the costs he's indicating that were requested by the city police department for their investigation of your case.
Okay.
The prosecutor also mentioned that the substance abuse assessment puts in quotes that you told them that you had 2 drinks and canned cocktails. Tell me about those drinks.
Yeah, I did want to mention that, but I didn't want it to sound like I was trying to make excuses for myself. It wasn't per se that I lied to her. They were larger cocktails, and like you'd really have to, I guess, do the math on trying to figure out how many exactly it would equal out to. So that was
what kind of alcohol is used in the cocktails?
Honestly, I'm not sure if it's a if it's a vodka base or what. There's a lot of cocktails that are like that. They're based with this, they say right on them, and I don't think it does. I'm not sure, but it's
How
but
large
it's like
are
a
these
Smirnoff. Oh, sorry. Is it like 20 ounce?
So you had 40 ounces of a alcoholic beverage when you say you had two?
Well, yeah, there was part of one still that was why I know that open intox got dropped, but I didn't finish it all. But yeah, about that. So I mean, I'm just saying that would explain why it was a little bit of a higher BAC, not because I per se lied. But I do agree that I need to be honest with myself as well.
What do you do when you work at your employment?
Mainly serve.
So you're not, are you a bartender there at Treetops as well?
It's kind of both, but I only work daytime. So it's not really like the bar environment, but there is a bar, of course, but it's mainly
Do you do,
serving lunch. And
do you do the bartending activities, or are you just a server?
sometimes I do have to do bartending activities.
So do you create mixed drinks or cocktails for the clients, for the people at the club?
Somewhat, but I mean, I don't really have many people order them during the daytime, mainly beer.
In order to be a bartender, you have to understand and know what's in your drinks. So I really find it
Yes.
hard to believe that you don't know what was in a canned cocktail, especially if it's called Smirnoff.
Well, like a high noon is mainly vodka based, some are tequila based, and it says it right on the front of the can. I mean, I don't have the can to look at anymore, but um, I I would assume it's probably a vodka base. It's like a Smirnoff Ice, but it's very similar to that. So Smirnoff is vodka, so I'm assuming it's vodka base.
Probably a good assumption. 0.17 is a high blood alcohol level. In fact, in Michigan, if you're above a 0.17, there's a more serious penalty if you were to be convicted of that. That's how high it is. In fact, it's double the legal limit for drunk driving,
I
which tells you
understand.
how intoxicated you were. Why would you, who have a prior drinking and driving related offense, why would you continue to drink if you've already had a problem?
Just
I
it was
get
a
it.
poor choice. I mean, I didn't for a very long time.
You're
And
right. It was
I made a
25
poor
years ago,
choice. Yes.
but here it is biting you again.
Yes.
What are you going to do differently this time so that it doesn't come back and bite you again?
Well, if I ever have a drink at all when this is over with, I'm never drinking and driving again, not even a drink or even a sip. And I'm sure that the counseling and the meetings are going to help, probably both in different ways. And so that will help with my mindset of it, because it's like I've already broken the habit of it, so I just need to keep in that habit, and that will help me with that. Talking to people, being honest, not being ashamed of it, I guess. I mean, it is kind of shameful. I don't want to tell anybody that these things happen.
Ms. Worm, here's my concern. It doesn't sound to me like you have made a decision to say, I'm not going to drink again. And you have the right to determine what you want to do with your life. But let me just say this as a judge. One time coming in front of a judge in an entire lifetime should be enough to say, that's an issue. I'm not going to do that anymore. Now, you've done that for 25 years, so I have to give you some credit. But you're standing in front of me today as a second time convicted person of the same thing. And you still have not said to yourself, this is a problem. I'm not going to do it anymore. You are saying to me, I'm probably going to drink again in the future, but I'll be careful when I drink. That's not good enough. If you are going to be a responsible member of society, especially if you're going to be involved in serving alcohol, you're going to be around it a lot. That's what you do. And there's nothing wrong with there's nothing wrong with that, but you have got to be able to say to yourself, I mean, this is just practical advice. This is not me telling you that you have to do this, but you're going to find yourself back here again, and it's not going to be 25 years from now, and I'm going to have to put you in jail. Do you understand that?
I do understand that, but I'm not going to end up back in there again because this is never going to happen again.
I'm sure you said that the first time 25 years ago, right?
I did say that the first time. But I didn't have to do any of the other steps, the counseling, any of that. I got an accident, but I didn't have this same, it was a different BAC. It was way, way lower. I don't even think it was. So, but I did not drink, and I know I messed up, and I don't ever want to end up back in the courtroom. And I think the counseling and the AA will help me. And I don't intend to drink again. I just only meant if I ever happen to have a glass of wine on a special occasion or something like that. And I'm not saying I will. I was just, maybe it'll be a non-alcoholic one. Because I don't want this to ever happen again. And now I have kids that have to deal with it too, and not just me. So it's a lot worse.
Yeah. So I'm hoping in the future you talk yourself, I'm hoping in the future that you can talk yourself into this, but right now you haven't got there yet. And that's disappointing. You strike me as an intelligent person. You strike me as someone who's well-spoken. I'm just hopeful that at some point, as you think about this, you realize that you're putting yourself and your kids and anybody else that's on the roadway at a high risk simply because you've not made a commitment to say, I don't need alcohol. It shouldn't be that big of a deal.
I don't need alcohol.
Good. Then I would hope that you would be able to say, I'm done. I don't need it anymore. 2 times in front of the judge is 2 times too many. All right, I'm going to stop preaching. I just wanted you to be aware of how important I think this issue is and how far from where you need to be I think you are. How you deal with it from here forward is up to you. But I'm just giving you fair warning. If you come back in front of me, you are going to jail, and not just for a day or two. So this is serious. And I want you to understand the seriousness that you're getting yourself into so that you can take all appropriate measures, which I think should be just saying, I'm not going to do it anymore. That's entirely up to you. While you're on probation, you can't have it. But you're going to live a whole lot longer while you're off probation than while you're on. So I wanted you to be aware of how the seriousness of this so that you can make proper choices. All right. Having said all of that, I'm going to put you on probation for 6 months so that you can have time to make your not drinking a habit again. There's a $180 probation oversight fee. There's a $75 crime victim assessment. There's a $50 justice assessment. There is a restitution amount of $345 to the Gaylord City Police Department. There are court costs of $300, fine of $150, and a local charge of $15. Let me add all of that up for you. That's a total of $1,115. That can be paid over the course of probation. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation department. You must enroll in and successfully complete treatment and educational programs. The substance abuse assessment recommends outpatient substance abuse treatment. And follow all recommendations. I'm going to also require the Prime for Life class. While you're on probation, you will attend self-help meetings with verification of attendance 3 times a week. You may not consume or possess alcohol or drugs. You may not enter a business where alcohol is served by the glass, except for employment. That does not mean that you may take home beverages from work.
Of course not. I never have, and I don't have a problem serving people. I'm at work. I just
All right. Just want to make sure that we were
and
clear.
thank you for not making me quit my job.
It's going to be difficult for you because you're going to be serving alcohol, and so you're going to be tempted.
Look,
So that's one of the reasons why I'm going to require you to go to AA 3 times a week and also take the educational class Prime for Life so that you can keep up with your ability to not give into that temptation. All right. I'm also going to require that you perform, well, what's your work schedule? I think we may have, Ms. Worm, what's your work schedule? Can you hear me, Ms. Worm?
okay, I can now. I'm sorry. I'm really sorry. I lost the volume there for a minute.
All right. What is your work schedule?
Generally it is at Treetops 10:30 to 5, Monday through Thursday. And then Friday and Saturday, I work at Hobby Lobby from 9 to 4 usually.
Well, you're going to have to take some days off because I'm going to impose some work camp days just to make sure that you understand how serious this is. Work camp is typically 7 to 3 or 7 to 4, and it's done Monday through Friday. I'm going to allow you to work that into your schedule. I'm not going to require you to do it in consecutive days, but I am going to give you 3 days of work camp.
Okay, so 3 days, but it doesn't have to be in the same week necessarily.
Correct, but it will need to be
There-
conducted within the next 30 days. So you've got 30 days to do 3 days of work camp. I'll let you work with the probation department as to when you're going to do those, but you will be required to do those. I want you to think about, while you're doing the work camp, I want you to think about how much more serious this could be if you were to ever do this again. So it's a reminder to you about the seriousness of this offense. All right. Anything else?
For me, no.
Mr. Dick?
Your Honor, thank you very much.
All right. That's all for today. Thank you.
Thank you.
Malcolm Burnell Oatmeal III, 26B 150-669A, B, and C.
Good morning, Judge and staff. John Graziano. Malcolm Neals to my left. Please identify yourself, sir. Malcolm Burnell, Oatmeal III, Your Honor.
How you doing?
Yeah.
Not too bad. So we have a possession of a controlled substance. We have a expired plate, and we have a no proof of insurance. First of all, on the misdemeanor charge of possession of controlled substance, does he stand mute and waive formal reading?
Yes, he does, Judge.
And then the other case, so he's going to now plead to that, and they are going to dismiss the no proof of insurance and expired plate, but he's also going to plead to distracted driving, correct?
That's correct, Judge.
And that's going to go on file B. Sadie, so we'll take the plea to distracted driving on file B, and then I'm going to dismiss file A and didn't say dismiss. I'm going to dismiss file C, no proof of insurance. I'm going to dismiss file B, original charge of expired plate, and then I'll take the possession of a controlled substance under 7411. Do you understand what that means, sir?
Yes, sir.
If you plead guilty under section 7411, what that means is I'm going to defer the proceeding. I'm going to take your plea. I'm going to place you on probation. And then if the conviction will not enter on your record, but if you violate the terms and conditions of probation, then in that event, the conviction will end up on your record. If you comply, the case will be dismissed at the end of the specified period of probation that I set. Do you understand that?
Yes, sir.
And do you understand under local ordinance, this is punishable by up to $500 in fines, 90 days jail, costs are all those?
Yes, Your Honor.
All right, did you sign, read, and understand the advice of rights?
Yes, I do.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. You understand that?
Yes, sir.
All right, to the charge, possession of a controlled substance, how do you plead?
Guilty.
On April 30th, 26, we're on telegraph near Mills in a motor vehicle in Brownstown Township at 9:50 p.m.
Yes.
And were you in possession of a controlled substance?
Yes.
What kind of substance? Okay. And to the charge of distracted driving, how do you plead?
Guilty.
Responsible?
Responsible. Responsible.
Where were the mushrooms at?
In a pouch inside of my car, sir.
And it was your vehicle, this 2014 Ford?
Yes, sir. Correct.
And did you put the mushrooms there?
Yes.
All right, they were yours?
They were mine.
Are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
I'm gonna accept your plea. I'll take it under section 7411. I'm also going to accept your plea to distracted driving. I'm going to defer the sentencing on that. I'm going to dismiss file C. We're going to set this for a sentencing. I'm going to address bond. Do you have any priors?
He does not have any priors, Judge. Just wanted to indicate if these, and then from a 2 to 3 weeks normally, which we have before sentencing, Mr. O'Neill is a wrestler, and sometimes he goes out of state.
What do you wrestle for?
We did the newly contracted for wrestlers, so I wrestle for about 3 different companies.
Okay. What, tell me, explain.
Last week I wrestled for Game Changer Wrestling. They're based out of New Jersey, but they travel all over the world. So I wrestled for them when whenever they're in the Midwest, so I tend to wrestle for them. I wrestled for another company called ICW. I've gone to England, Japan, Australia.
Wow.
All types of places doing this.
Are they paying you as much as they paid superstar baseball players? I mean, you're making 39 million, 42
Listen,
million.
I wish. I get paid in pats on the backs and bruised body. That's it.
No alcohol, no marijuana, no illegal controlled substances. You're not.
But Judge, I just want to let you know, he had a medical marijuana.
Is that true, sir?
That is true.
And do you have proof of that now?
Yes. It did expire though, I believe several days ago. Yeah, about a month ago.
Well, I'm not gonna address that then. You're gonna have to get a new medical marijuana card.
Absolutely.
but no alcohol then, no marijuana, no illegal drugs. You cannot leave the state without the consent of the court. Do I need to have a provision here for, when's the next time you're supposed to go out of state?
Right now, all of the dates that I have are,
Are they after June 18th?
I don't have anything out of state, planned until, July.
Okay. We're gonna do your sentencing on June the 18th at what time, Heather?
Oh, sorry, 8:30?
8:30 in the morning, okay? I'm gonna order a screening and assessment. Like I said, I'm taking your plea, possession with controlled substance. You'll go down the hall, you'll get your notice, and then you're going over to probation where you'll fill out a questionnaire and be interviewed, and then you'll come back on June the 18th, okay?
Yes, sir. Thank you.
Any questions?
No question. Thank you, Judge.
Thanks a lot, Mr. Graziani. Good luck, sir. Good luck with your wrestling. That's interesting.
Thank you, Your Honor.
Tyler Keith Tillery, 26G 306-839-A and B.
Hello, Judge Marty Dawson, appearing on behalf of the defendant, Tyler Tillery.
All right, so he's going to plead to operating while visibly impaired on file A. The super drunk will be dismissed on that. And then he's pleading to, the only problem is, let me see something. Did you pay the PBT refusal?
Yeah.
Yeah, he paid it.
Okay, so he's already taken care of that.
Yeah, so then so I don't have to take a plea on that, and then I'm just gonna go ahead and dismiss just confirm that with me, will you, Heather? He did pay that. I remember that from last time. Is that right?
Yes, he did.
So I'm just gonna take your plea to operating while impaired, dismiss the super drunk, dismiss the violation of restrictions on license, and I don't have to take a plea to PBT refusal since you already paid that money, which therefore was an admission of responsibility. Operating while impaired is punishable by up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your vehicle, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes.
Did you sign the advice of rights and read it and understand it? If you plead guilty, you'll be giving up all those rights, and we will not have a trial of any kind. You understand that?
Yes.
To the charge, operating while visibly impaired, how do you wish to plead? Were you operating a motor vehicle on Monroe near Bayview in Gibraltar, March 3rd of 26 at 10:33 p.m.?
Guilty.
No, were you operating a motor?
Yes.
Okay. On that date and at that time and at that location?
Yes.
And prior to that, did you drink alcohol?
Yes.
What did you drink and how much? Don't lie to me.
6 beers and 6 shots.
Okay. And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol? In what way? Why were you pulled over by the police?
Because I had this.
You ran through a stop sign?
Yeah.
You think you did that at least in part because of your alcohol consumption? And counsel, was there a blood draw with a result of 0.216?
Yeah.
And you stipulate that was accurate for purposes of the plea?
Yep.
Are you on probation or parole?
Right now.
Yeah. Anybody force you to plead guilty?
No.
Plea is accepted to operating while impaired. Again, as I said, the PBT refusal he already paid. I'm dismissing the super drunk and restricted license violations on the motion of the prosecutor, referring you for a screening and assessment. Have you been going AA?
Yes.
You're on a sober link, right?
Yes.
I told you how concerned I was that you're only 20 years old and you went out and got this, right?
Yes.
So you're not doing this anymore, right?
And Judge, we talked about the bribe.
Yeah, I'll be glad to take them in.
He wants to take advantage of it.
Okay, good. Sobriety court. So we're gonna set the sentencing out, so he's gonna go through the bond phase, okay?
Yes.
Tell me when you can, give me a date. Heather, I'm thinking, let's see, this is already May 21, July the 15th or there, maybe, yeah, around, right when I come back from, yeah, around the
Well,
12th.
You would have sobriety court on the 22nd. Do you want it on a sobriety court date or just on a Trenton day? Or I'm sorry, Gibraltar day?
Really need it on a sobriety court day. Let's just do it on, I don't even need it
The
on a
16th.
Gibraltar day.
Okay. The 16th would be a Gibraltar day. And that's the week after you come back in July.
Then let's do that. The 16th will make it at 8:30. Okay, Mr. Duncan, is that
Yeah.
good with you?
Yeah.
Okay, so young man, I look forward to this. You seem like a nice kid. We're gonna help you out here. Don't lie to me though, ever, okay?
Thank you, Judge.
All right, thanks a lot. Have a good day. Good luck. Go over, you're going to get your notice and then you're going over to talk to him about probation. Thank you very much. Jessica Anaya. Jessica Lynn Anaya, 25R254240.
Good morning, Judge and staff. Jessica, John Bautista, agreeing on behalf of Jessica and I. She's at my level. Please identify yourself.
Jessica and I.
All right, so your client is in here on probation violation. It is alleged that she failed to attend her scheduled probation visit on May the 11th, failed to pay fines and costs as ordered, failed to clear all warrants by May the 1st. How is she going to proceed on those?
Judge, we plead guilty, but obviously with an explanation.
Is that what you want to plead guilty, ma'am?
Yes, sir.
If you plead guilty, that would be 3 technical violations. I'm just not trying to scare you. You could get 15 days. Do you understand that?
Yes, I do.
And you understand that also your 771 status could be revoked, the conviction entered. And again, you'd be subject to that jail term.
Yes, I do.
And did you sign, read, and understand the advice of rights revocation and probation form here today?
did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand? Can you call me Madeline, please? Count 1, failure to attend your scheduled probation visit on May 11. How do you plead?
Guilty.
Count 2, that you failed to pay your fines and costs as ordered. How do you plead?
Guilty.
Count 3, that you failed to clear all your warrants by May the 1st of 26. How do you plead?
Guilty.
Did you fail to report to probation on May 11th?
I did, and I actually emailed her the next day because I didn't realize it was the day before, and she said that she had already sent it over to you as a violation, that her hands was tied and there was nothing that she could do at the moment.
Hang on, just answer my question. Did you fail to clear all your warrants by May 1?
Yes,
Anybody force you to plead guilty?
no,
Let me see. I'm calling probation in here. I'll accept your pleas as the counts 1 through 3. I sentenced you on March 19th. Why hasn't she cleared her warrants?
Judge, she put it simply, she's really destined. If it wasn't for her family, her mother who's sitting in the courtroom, she'd be homeless. I'm surprised looking at her financial situation that she even made a payment of $100.
Does she work?
She's not working, Judge. Again,
She has kids though, right?
I believe, child. She's got 3 children, and again, transportation remains an issue for many of these families, and Ms. Anaya is no exception.
Your name?
Probation.
She's not doing well. Huh? No.
Thanks. She did put work program for 2 days in her day of community service. Other than that,
How are you supporting yourself, man?
it's pretty hard.
It's food stamps, Judge, that she has for herself and her children, and she's not getting any child support at this time. She is living again with her mother, who's in the courtroom. She's likely to check it on, and if it wasn't for her, this person would be homeless. Judge, I'm expecting, quite frankly, even more issues because of the transportation situation.
Well, you'll Zoom with her on.
it's on Zoom. The Class A program is on Zoom. She can pay online.
Right.
The only thing that she would need transportation for, she has several warrants to clear still. I told her to call those courthouses and see, because every court has a different procedure for canceling warrants. I don't know if they do it in person. Some offer to pay online and will close it. So that I don't know. But anything else can be done virtually.
When did you last work, man?
I did tell her I just got a job, but due to
Yes.
my transportation, I just had to tell them to take me off the schedule. Just simply so I didn't get fired. I'm not a bad worker, so. I do have that job still, however, she's holding it for me until I get a better source of transportation.
Where's that child located?
It's in Monroe. It's a cold restaurant.
But you're living in Detroit, right?
No.
Where do you live? Oh,
Where's her mother?
okay. Do we have her updated address?
Yes, it's Dittner, Rockwood.
Okay.
Yes.
It's not, I thought you were coming from Detroit. It's not. Look, I'm gonna let you get your life in order here for a minute. I'm gonna adjourn the sentencing for a month. I will adjourn the sentencing. I'm accepting your pleas. We'll set a sentence date. She can try to save some money. She can get to other courts to resolve her warrants, set sentencing. Why don't you give me a date in the latter part of June, if you would, Heather, please?
June 22nd at 8:30.
Okay? I don't mind if you Zoom if you can't get here, but you
I
don't live.
did text her the next day. I texted her, said I didn't realize it was that day.
Yeah, I know, but you gotta just be a little more responsible.
She emailed me about something else, but I let her know, hey, you missed your.
You gotta be careful, okay? We'll see you in a month. They'll give you your notice down the home. Go get it. I'd like to see you here in person. If your mom can't take you, I'm not opposed to you being on Zoom, okay? Good luck.
Judge, thanks for your compassion.
Have a good day, young lady.
Thanks.
Thank you.
Thanks. People Against Summer, Lori Greathouse, 25F245-336. Your name, ma'am?
Summer Greathouse.
Mr. Longton, your appearance? I need to read you both something that was handed me today. And I'm not trying to create any more problems here. For her and her ex-husband or estranged husband. But I need to read this to you because I'm not going to conceal anything, obviously. He just says, to whom it may concern. Who am I hearing right now, Heather? Can you tell me?
I believe it's the jail background noise.
Okay, I'll keep my voice up nice and loud. I am writing to you as the sole legal property owner of the residence located at 30,001 Huron Meadows Drive, Rockwood, Michigan, 48173. I'm aware that the defendant, Summer Greathouse, is currently serving a jail sentence under your jurisdiction and has an upcoming court hearing. Please be formally advised of the following. 1, no consent for tether/ankle monitor location. I do not consent to my property being used as a designated residence, base station location, or monitoring site for any court-ordered electronic tether, scram device, GPS tracker, or house arrest equipment. 2, revocation of residency effective immediately. Summer Greathouse does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number 3. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. 4, clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court. Specifically during her prior bond violation hearing, I'm advised she may attempt to claim her immediate release is necessary for childcare. The children are completely safe, stable, and cared for in my custody. Her claims of childcare hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so their defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file, respectively submitted, Harrison Steves. So with that,
I can respond to that.
you can respond whatever you want.
Because there's a lot of falsehoods in there.
Hang on a second, hang on. You asked for a hearing, you filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that the defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late SoberLink blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was, or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
Well, what he's done. He's trying to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
Yeah, that's correct, John. You did not. But I wanted to make that clarification. I know my client is dying of me to address what you read in the record of that letter.
Okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an expired order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary care, custodian of his children since birth. The biological father, the never married mother, has not been a primary caregiver, not been the co-custodian. He's seized on this. Then we grab custody, and I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you, Mr. Are you Mr. Steves? Are you Mr. Steves?
Yes,
Okay, he's in the back. Go ahead.
I have no doubt that his children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can care to by her own. That's what I'm asking. She has learned her lesson. There's no doubt in my mind she has learned her lesson all about honesty with his court and fucker.
You can't lie to the court.
Your Honor.
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I doubt that. And you don't.
Your Honor.
It just underscores how she has not taken this seriously. Listen, I wanted to give you this hearing only because I wanted to clear up this record. I did not say anything about bond conditions. That is not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program. If you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No, but you can't just say I can commit all these crimes and then say I want to put it behind me.
I will
This
not.
is the thing. This isn't a simple isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people who through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Will
The
not
motion
have
for
a
reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day.
Court calls the case, People versus Justin. Yeah, was that Justin Chaps?
No.
I'm sorry.
Really? Can't hear me? Can it? You can't, it's you. Good. Thank you. Your name, sir?
Justin Heaton.
And sir, you were intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of things. First of all, there is some danger in representing yourself. You'll be held by the same standards as an attorney in courtroom. The court is not here to assist you in that manner. I will presume that you would know the court rules and the manner and procedures. You understand that, sir?
Yes, Your Honor.
All right. I do also have to advise you that you're here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right. What would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court to decide that. Yes.
On the court.
To decide the next procedure.
Sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay.
Okay, what?
No, thank you.
Okay.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to my best wishes.
The next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed.
Pardon?
Proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the
Your Honor, our office has not really been able to deliver just summary. We would be asking for at least one of the journals to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request proper paperwork before today, yes.
You requested it from whom?
From the jail upon.
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today,
At any point. Sir, I'm going to ask you again, do you wish to be represented by an attorney?
no.
All right. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter. How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit.
Well, I'll give you two, because they're gonna have to arrange a way for him to look at it, and I don't. Probable cause conference, court's gonna find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 a.m. On in this matter will continue. Thank you. So that we're clear, I'm denying the request to release the defendant at this time. Court calls case, People versus Alan Fuqua.
Go over for the piece of ready?
Morning. Morning, I'm Rob J. Kill on behalf of Mr. Watt. Approaching the podium. Fuqua. Judge, I was just appointed, but I did meet with Mr. Fuqua yesterday for a good hour and a half. I know what the situation is. I have all discovery. Want to
have it all.
Want to set this for exam.
All right. People have their witnesses available the second. All right.
Judge, may I address bond?
Yes, preliminary examination in this matter will be set for June 2nd, 2026, 9 a.m. before Judge Washington. All right, go ahead, Bond.
Just very briefly, my client was driving. He had just bought this older pickup truck, did not have a plate, which was the reason for the stop. He does have a valid license. That being said, he was pulled over. He was cooperative with the police. In the back of the pickup truck in the bed, which had a tarp covered, they found a pistol. It did not belong to my client. He did not know it was there. There was also ammunition that was not correct for that gun inside the cab, which my client admitted having. That being said, sole caretaker of his mother, actually Trinity Health, his mother's caretaker. She now lives in an apartment temporarily while the house they did live in caught on fire and is being rebuilt. All that being said, Judge, I'm asking if
Going to be an objection to release them.
There would be. The people are greatly concerned given the allegations in this case. The firearm that was found was a printed gun.
Was what?
The gun, meaning there's no ability to track it. There could be the ability to have some additional firearms in the future. The ammo did not match the gun. That could suggest that there was an additional firearm that was not found. The ammunition that was found were hollow point bullets, meaning that they would cause grave bodily injury if they were shot at a person. The defendant.
But not illegal. Okay, go ahead.
The defendant was an initial offender by 1988. He has 3 convictions for homosexual conduct second.
When was his last conviction?
2000. In 2000, he spent 18 years in prison, Judge. He's been on parole since 2018. Again, Judge, I got off. He was off parole in 2018. I'm sorry. I'm just asking for it. He did show the officer that the guy did sign off on the title, just hadn't got a plate yet. Again, I'm asking more just for leniency because this is sole care.
Just buy the truck? Is that the deal?
Yes, Your Honor. It was a used truck. He had just bought it. Yeah, the person signed off the title. Again, because he's a sole caretaker of his mother who's temporarily living in an apartment while their house is being built. He's agreeable to home confinement, tether, anything the court wants to give because he's going to stay there with his mother while he takes care of her.
He's not currently on parole.
Correct.
When was his last conviction 25 years ago? Or longer than that?
Yes, Your Honor.
No information to see that it's.
Well, look at your bond form. It says he's a convicted felon, heavily assaulted, dangerous criminal history, but so I'm trying to figure out why the magistrate set a $250,000 bond on this case. And it seems that that's the basis for it. But my understanding, at least as of now, is that was over 25 years ago. Or the conviction actually may have been before that, but 25 years ago. And he has no convictions in those 25 years.
I'm being told the date was 2003, but so it would be.
Okay, so 24 years ago or 20, whatever.
Judge, to be honest with the court, he was in prison for almost 15 years. He was released. He got off parole. He was paroled. He's got off.
When did he get off parole?
2018.
And hasn't had anything since?
No, Your Honor.
Where does he reside? In Ipsy?
It's temporarily, Your Honor, with he and his mother would be staying at, I think, what's the address? 910 Maplewood, apartment 2, while they're home on what street?
789 Calder.
Calder's being rebuilt, Your Honor, which should be done in the next couple months.
What is his temporary address?
The temporary address is
910.
No, who's there?
Just his mother.
So that's his mother's address.
Correct. And he's a caretaker for her, being paid by Trinity Health. I dropped it.
Anything else?
No, Your Honor.
All right, I set it for exam on the 2nd. I'm going to release the defendant on $25,000 personal recognizance bond. However, a condition of that bond is he's to be placed on a home confinement GPS tether.
Thank you, Your Honor.
Thank you.
Chairman.
Court calls the case, People versus Kanga.
Please state your name for the record, sir.
Stevie Kinga.
Kanga, apologies. Your Honor, I did speak to Mr. Kanga. He has asked that we adjourn this matter to review discovery and talk to about a potential resolution. If, I don't know if the court was gonna do the June 2nd date, Mr.
For what?
For his next day, Judge.
Why would I he's not asking for an exam.
Okay, just want to make sure. No, Judge, not.
Why?
Why
why is he doing this?
I'm talking too much. I'm sorry, Judge.
I know.
I'm done talking. My apologies.
I'd be done by now, but go ahead, Feaster. I'll wait.
Enough to say, Judge. I apologize.
Oh, no, you're not apologize. Don't accept it.
Whatever date you want, Judge.
I know. You were stopping me before I even said anything.
I shouldn't have.
Then gave the wrong date.
I did.
And then
we all make mistakes, Judge.
You see?
I'm sorry.
Here's what I was talking about before I came.
My greatest apology.
Somebody is trying to pressure me to
No.
No, you're doing that to me.
I'm sorry. I didn't mean to.
No, I expected it from Chinaza, not you.
You're right. She does that all the time.
I know. All right.
Whatever PCC date you want, Judge, I'm sorry.
I know.
I'm done talking.
Yeah, stop talking. Sir, will June 11th work for you?
Yes, Your Honor.
All right, very good. We got all through that. PCC will be adjourned June 11th, 2026, 9
Your
a.m.
Honor.
Thank you, sir.
Apologies, Judge.
No, why do you apologize when you don't mean it? Court calls the case, People versus Stefan Scott. I said that.
Yeah, is that we have, peaceful, Your Honor.
David I. Goldstein, hearing on behalf of the defendant. There you are.
Your name, sir?
Stefan Scott. Your Honor, at this point, I have received no discovery.
I don't think we have an appearance entered in our stuff, so I told Mr. Goldstein to inform me the appearance of momentary for Wednesday.
Well, Your Honor, that may be true that they may not have a written appearance, but I have spoken to Ms. Tenhouse several times and asked her for discovery, and I have not received it. Nothing to do with Ms. Enda, but
Comes to me against the house.
Is there, well, but my understanding is it's sort of an automated process. Once it's sent in, the discovery's then sent out.
Last we had it sent, I believe this to Mr. Kilwall when he was originally on before Mr. Goldstein got back. Okay.
if Mr. Kilowall doesn't have it, I'll tell you, because I asked him for it.
Doesn't have it?
No.
I think we found a USB because there is over 1,600 pages of discovery, and then each of those is like separate police reports. I believe it's on a USB at our office.
Your Honor, I don't have a problem with an adjournment. I did file a green sheet, but I just want to.
No, I know. But I also want to make sure I don't get back here and then we don't. Because if Mr. Kilowall didn't have it, if it's on a USB, that may be because he might not have picked it up, but I want to make sure that it's failing.
The problem is this case went from A to B to C to D. I'm the D. Mr. Kilowall was either the B or the C. He kept switching to different people, which is one of the reasons why it took a while to get the substitution done. Because we were always one step behind, but.
Got it.
So if it's not entirely your office.
Because I still have, I have Mr. Goldstein now on the case.
Yeah.
Okay, so I guess I want to make sure the discovery is going to be available for pickup.
Yes, I believe Mr. Goldstein needs to bring a USB with him, and we have it ready to copy over.
How big a USB? You know what? I've got an external drive that holds a lot. Yeah. Okay.
Okay, good. We got all the technical stuff worked out?
Yeah, now comes the fun part, Your Honor, which is the issue of bond.
It might be fun for you.
If I can.
How long an adjournment did you want?
Well, I'm going to be gone the month of June, so I'm talking about early July.
Okay. Can do July 2nd, is that right?
Hang on, let me check. I think that's good, but let me check. I'll make it work, Your Honor.
All right.
Now, on the
double cost conference will be adjourned. I'm trying to avoid.
I know you are.
That's basic.
You're doing a good job.
I know. All right.
All right, I'll try to make this as brief as possible. 14 months ago, my client was charged with some charges. Those charges were pending until about a month ago, when on the eve of trial, prosecutor's office nollie prost, and then turned around and filed the charges you have in front of you. None of them are new. All these dates go back to early 2025. So he basically sat in jail for a year. They then dismissed it and charged him with things they could have charged him over a year ago. Now we come to do the probable cause conference, and there's no discovery. Now, it's not their fault. I'm on vacation next month, but it's going to be another 4 or 5, 6 weeks before we can get back into this court and we can start moving forward. And none of this was at Mr. Scott's insistence. He was ready to go to trial all the way through.
And the case kept sitting and sitting, and then they walk in and dismiss it. And I'm not going to argue the issue whether he's entitled to credit, because that's not for you to decide. But one of the consequences of him sitting for a year was that nothing happened, and B, he could now lose the credit for that year.
But so that I'm,
Okay.
or from the people,
Go ahead.
so that I'm clear, the original charges that he was sitting, did he have an exam on that case?
I wasn't representing him at the time, Your Honor, so he did. Yes, he did.
So he had an exam, was bound over, waiting to get to trial, and then at the point of trial,
They nolly-prost.
nolly-prost.
And some of those charges that they nolly-prost are included in the the complaint that's in front of you now. And then there are additional charges, but those additional charges could have been brought a year ago. And they chose to wait a year and not charge them. So at this point, Your Honor, I think it's only fair that he.
Well, but hold it.
Okay.
You're saying they could have been brought, so they didn't arise.
No.
Okay.
In fact, if Bernstein is still here, he represented Mr. Scott at the time. They even argued some of those at the time of the bind over, but they were not added as charges. None of this is new. If you look at the dates in your complaint.
They argued it, they weren't added.
They tried to get in some testimony at the preliminary examination, some of the same information some of the same charges that are contained in the complaint that you have, and Judge Barr would not allow it. But they never moved to amend or bring those charges until April of 2026, a year later. So the case sat for a year, and those charges could have been brought either as an amendment to the information or as a separate case, and they didn't do it.
Response.
I did not handle that exam for the previous case. He was previously charged, I believe, with ag stalking. And at that exam, the victim did appear and testify. And after that exam, after speaking with her, it's my understanding that our office had Detective Pearson or Soiring do a supplemental interview with her to go back over the entire history of their relationship and the domestic violence that occurred within that relationship for a potential new case that was submitted. That case was submitted, and that report was, I believe, 1,600 or so pages that Ms. Tanner had to review and go through and speak with the victim about before deciding what charges were going to be issued. And in that report, it does detail the 5.5-year relationship and numerous acts of domestic violence, including times that the victim was seriously physically assaulted to the point of having injuries and being assaulted while holding her child, thrown in a closet and choked. The child was taken to the hospital for weeks. There's other assaults that are detailed here that include her suffering extensive bruising, bleeding, difficulty walking, incidents of the defendant being at her house when police arrived, him telling her not to contact police and to tell them that everything is fine and have him come out after they leave, incidents of the defendant contacting her. Along with that, this extensive history points which the defendant was incarcerated on those previous cases that she did not appear for because of him intimidating or interfering with these cases. There was thousands of jail calls. I think at the end of that supplement report, what was submitted was a call log that included 1,004 completed calls during the pendency of those previous cases to the victim that were included in that report as well. So this is an extensive review of that entire domestic violence relationship, including potential for sex trafficking charges for this victim as well. I mean, it's just an extensive history of violence and aggression and abuse that this victim faced that we needed to sift through with her and the detective to get a full picture of what potential charges could even be coming for this case.
Your Honor, it's a little unfair for her to give this litany of things for two reasons. One of which, this is neither the prelim nor a trial. And number two, I can't respond because I have not seen any of that material. So I think it's a little unfair for that to be brought up. You can see what the charges are. You've got the complaint in front of you. You can see the dates of the alleged offenses. And Ms. Enda has now indicated, yeah, they've had this information for a year now and did nothing. And it's just, so he basically was asked to give a year of his life while they twiddled their thumbs.
So, because that's not entirely true, Mr. Goldstein. I mean, at least the way that you make it seem, because he had a prelim. and was bound over on the prelim. Now, as to what court scheduling or anything else along those lines, I can't speak to that. I mean, I get it that he's there, but then they come in and they dismiss the charges, but then they bring these back.
I mean, the only thing I disagree with what you just said, Your Honor, is they could have brought these charges a year ago. And now we're starting all over.
I mean, I hear what you're saying, but I don't know that. I don't know how ripe the charges were. I can't say that. Or whether or not they had all of the information. I mean, I hear what you're saying and that they requested that some of these be added, but.
And that's really as well from my review of our notes. What an extent of what this is was discussed, but it was not the full extent of the sit down. I believe the interview was like 4 or 5 hours with this victim going over this history. We did not have that the day of the exam being.
That's correct, Your Honor. But when was the interview? It was done within days of the exam. And they certainly knew some of this
after the exam. Which means he.
Some of it, yeah.
Not, right. I mean, okay.
Yeah, that's correct. That's correct.
Which means they couldn't have just added them because he would have been entitled to an exam on any added charges anyway.
Right. Any added charges. There's some information they already had, some information they got later. I can see that.
Well, okay. Anything else? At this point, I mean, certainly I would hear anything or get this thing set, but the discovery is now ready, given the adjourned date. At this point, however, I'm going to deny the motion for reduction in bond. His bond will continue as is, and certainly feel free to address it once you've looked at the discovery on July 2nd. Then. All right. Thank you. Court calls the case of the people. First is Daniel Heelan.
Michael Gaddy is the public defender on behalf of Mr. Keelan, Your Honor.
Who's that? Why? Who's that?
That is the one that's very important to.
Who is that?
Say,
Who is that? What? Why?
This is Casey McGee, Your Honor, a legal fellow in our office. This is Mr. Healy.
A legal fellow?
Yes.
So
law grad.
Why didn't they introduce me to her? I know she's been here a long time. She's in my well, and you didn't introduce me.
My apologies, Your Honor. I assumed you had met her before. This is Ms. McGee, Ms. McGee. This is Judge Simpson.
We'll talk later.
Okay.
It was nice meeting you.
Nice.
These people are so rude. All right, let's go ahead.
Your Honor, we're here. I think we might have a resolution that involves a misdemeanor plea in this matter. We were notified of a bond violation as well.
Has he been testing?
Your Honor, Mr. Heelan was at Bear River. He was released from there, and now he is with Home and New Vision doing outpatient. He has been. We did reach out to Home and New Vision for testing. We haven't heard back from Ms. Aoka yet. But I was going to ask the court to perhaps adjourn this a couple weeks to allow us to get any information for them. On the good side, he does have a job. He's working full-time at the car wash. He was just approved for his housing voucher, which he's been waiting for a long time.
Miss Pantanika, I'm sorry. Miss Pantanika would like you, if you need to confirm it with her. So
who?
Pantanika Blade. She said she discussed housing issues with you last week, sir.
I believe she works at Pathways or CMH, Judge.
What's her first name?
Blade.
Okay.
I just got picked, Your Honor.
Pardon?
I just got picked. I just got approved for my housing.
For your. And that was through her, got it, okay.
Your Honor, unfortunately, it's not unheard of for someone to be an IOP and continue to use. Unfortunately, we don't have the results today. I, in general, don't have an issue with adjourning it. I wonder if we could do a test today, right now, and that might give us some guidance into how things are sort of going. I do know that the defendant did quite a bit of time when he was at Bear River, did some good work up there, so hopeful that we won't have any issues if we test today.
Your Honor, yeah, as I said, he is working with Home and New Vision. This is a long process for some folks, but I'm not going to swear.
Council Prosecutor, I need you to get a test today, okay? And I want the results, and then I'll call your case up in the next block. All right, which starts at 12:30. Okay? All right, I'll pass it.
Your Honor, just for clarification, does Your Honor want me to get the information you asked for first, or do you want to test first, or?
I want to test first.
All right, thank you, Jim.
And well, simultaneously, I want to test first, but I need to get that information.
Thank you, Jim.
All right, thank you. Court does call the case, People versus Daniel Phelan.
What was that name, Your Honor?
Phelan,
Michael Gaddy, Assistant Public Defender on behalf of the Mr. Heelan's making his way to the podium, Judge. Your Honor, Mr. Heelan did go to the testing facility. He didn't have the appropriate funds, so he was not able to pass. I did submit some documentation to the court, and I believe the court has taken some steps to verify it.
How often are you tested by CMH?
I'm gonna be testing weekly, sir.
You'll be testing weekly?
Yes, sir.
All right, what I'd like then, what I'm gonna do in this case is, I realize you had the funds to test today. I'm gonna do it in a way so that your housing's not jeopardized. We were able to verify that you were selected. Congratulations.
Thank you.
And I know where you'll be. One of the reasons that I was gonna do this is because of where you'll be. There's services that are surrounding you, which can lead to your success in it. And so I'd rather not interfere in all of that and won't. Okay?
Yes, sir.
You need to, and work with your attorney, I need a release from CMA. So you did the intake over at Community Corrections,
Yes.
right?
Yes, sir.
So can we let Community Corrections know that I'm gonna allow him to test through CMH? Because you're not employed at this point, right?
I'm supposed to start a job full time, but I don't know when. They're waiting for some, it's one of those, yeah.
I got you.
Yes,
Okay, so what I'm gonna have you do is we'll sign a release. He'll test through CMH at this point,
Yes, sir.
with a release to Community Corrections of the results.
Thank you.
Okay?
Yeah.
And they also just indicated that he had been chosen off of a list of program that I'm familiar with, so it's a great opportunity.
Yes, sir. I'm so thankful. So thankful.
When's the last time you were housed for this?
A long time.
Yeah.
Long time.
So good things are happening. You get Bear River, right?
Trying, I'm trying.
Okay, you just got to keep up the good work, right?
Yes.
And like I said, there isn't, in my opinion, there isn't a reason for you to fail because you got so much surrounding you now.
Yes.
That to work it.
Yes, sir.
All right. And Mr. Getty, you needed an adjournment.
Yes, Your Honor, I did prepare a green sheet.
So we can get a number of tests, and I'm going to adjourn this to June 18th, 2026, 9 a.m. Bond will continue. All right, take care. Court calls the case, People versus Justin Mosier.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge. Portia Feaster, Assistant Public Defender on behalf of Mr. Moser Police Station.
Justin Moser.
Thank you, Judge. We are requesting an adjournment in this matter. Mr. Moser has prepared his own mitigation information. I'm going to submit to our social worker to tighten it up for the people there.
Got it. June 18th,
Thank
Thank you.
2026, 9 a.m. Oh,
Just wanted to see if there's any testing or significant.
are you testing at community corrections, sir?
No, I'm not, sir. I'm not aware. I'm currently working with the CMH.
Hang on,
Good.
hang on. I don't see a testing one.
I think you're requesting that some more testing that would be a sober lane before. For instance, in the report, I believe it was indicated that the defendant was smelled of infectious incident at the time that this happened essentially. In his truck, in his driveway, playing music while it started off as noise complaint and then escalated. Likely due to those symptoms.
Sorry, sir.
Just ask if the board considers some testing to potential alcohol. If we have later more.
Your Honor, I believe this is a mental health situation and not a substance abuse situation. Mr. Moser's already getting the treatment he needs through CMH. He's taken the matter very seriously. He's had no violations of any other type. I'd ask that the bond condition stay as is. And I think our social workers and CMH can put together the appropriate mitigation to show the court and people how the situation occurred.
Mosher, if I sent you over for a test today, would you test clean?
I'll test clean, sir.
You would test clean?
Yes, sir.
Okay, why don't I do this? Other than any medications you may have, you'll test clean. All right. Want him to go over, get a test. I'll call him up in the next block. I'll use whatever the result of that in consideration of whether or not there's any alcohol testing or anything like that.
Thank you, Judge.
What was the date for the interview? I missed that.
The 18th.
18th.
I will explain to you what he said.
Okay.
Okay.
The CMH said that they were going to maybe have me test there. Would it be possible to test with a CMH and then provide those results?
That may
See what happens.
occur later, but I want to test today.
Okay, sure.
All right.
Thank you, Judge.
Thank you. I'll pass that. Courthouse case of People versus Justin Moser.
Afternoon, again, Your Honor, Raymond Cook for the people.
First Assistant Public Defender on behalf of
I don't
Moser.
have my time.
Justin Moser.
It's probably on the table. Mr. Arrow.
Mr. Moser to go test. I don't know what the results of the test were, but I guess they weren't positive.
Weren't good.
Okay.
Well, they were positive.
But
Very.
yes.
What's the deal with opiates in your system?
You know, I was prescribed methocarbal for extended back pain, and I wasn't able to fulfill that prescription because I was switching to get Medicaid. And the prescription was too costly, so I had really bad back pain last night, and I did take one pill that started with hydro. I'm not sure exactly what it was. I think it was an opiate. I didn't know it was an opiate. It was the only time I took that pill for the back pain. So I'm still waiting for my insurance to be corrected so that I can get the appropriate medication and go from there.
So your prescription, when was the last time you had that?
I have been going to the doctor as of recent.
Hang on. The only thing that can make this worse right now is for you to lie to me.
Okay.
I've been here a long time. I've heard a lot of stuff.
It's not my intention.
So no,
Listen.
a lot of people lie to me and don't seem to intend it.
Right.
So I'm gonna let you take a breath and start your story again. Why is there opiates in your system?
I took a pill last night for back pain that said hydro on it, and I wasn't. If I knew it was an opiate, I wouldn't have taken it. I didn't know it was an opiate.
Okay, what the hell, I'll ask. What do you think it was?
I don't know. There's several different back pain medications, and I took it for the bad back pain that I have because I couldn't fulfill my prescription that was from the doctor. I'm switching from Medicaid to from another insurance company.
I heard you.
And so I'm sorry. Like I said, I took a pill that was apparently an opiate. I'm willing to.
You're not supposed to be taking any illegal drugs. That drug is illegal for you.
I was unaware of that. And I'm completely sorry.
How are you unaware of that?
I'm not an opiate user. I don't use opiates. And I didn't.
Well, you do now, apparently.
So I didn't. I'm sorry. I'm willing to test it or follow the court's advice to correct the situation.
So when you said you test clean,
I thought I was
fine.
clean.
Said you test clean, but you knew you took a pill last night.
I was unaware that it was an opiate. That's the biggest thing that's why I was so sure of it. I was 100% sure that I was going to test clean.
I realized I had given you a date. I'm going to move the probable cause conference up to June 4th.
Thank you, Judge.
At this point, the defendant's bond is hereby ordered to revoke violation of his conditions. Defendant is remanded.
Thank you, Judge.
We will go on the record in the matter 26 CF 43, State of Wisconsin versus Alicia Roseland. This date appears through District Attorney Kevin Schmidt in person. We have Ms. Roseland in person with counsel Eugene Harrington. We're set today in this matter for preliminary hearing. It will proceed. Please call your first witness, Mr. Schmidt.
I call Andrew Tyler.
Officer Tyler, please come forward. You're going to raise your right hand. You'll be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I swear.
All right, you may begin.
Can you state your name for the record?
Andrew Tyler.
What do you do for a living?
I'm a police officer for the Village of Siren.
How long have you been so employed?
Been employed there since August of 2025.
Did you respond to a call of a disturbance on March 21st, 2026 around 2:50 a.m.?
Yes.
In Maple Lane in the Village of Siren?
Yes.
Did you go out there?
Yes.
Where did you go and what'd you see?
Went into the house. When I entered the house, I met the victim and she brought me downstairs. When I went downstairs, I met the two suspects and three victims at that time.
Before we get into that, the residence you went to is in Burnett County?
Yes.
Okay. So you made contact with a number of people. What'd they say?
When I entered, the victim was upstairs. Initials D.O. was upstairs. She said they were downstairs. When I went downstairs, I was able to separate the two suspects from the victims, and they went upstairs. And I spoke with the two victims that were downstairs.
Who were they and what did they say?
Initials were JT and DO. Said they were downstairs in the room when the suspects entered the house, went downstairs, entered their bedroom, and attacked them.
You said suspects. Did they know who attacked them?
Yes, it was Alicia and Rhea.
They specified it was those two.
Yes.
You actually saw the Alicia who was there?
Yes, she was in the basement when I entered the house.
Do you see that person in court here today?
Yes, she's seated next to the defense counsel in a black sweatshirt.
Let the record reflect that Officer Tyler has identified Alicia Roseland.
Did DO or JT describe the circumstances leading up to them being attacked?
Yes, they said they were in their room.
Object to the form of the question. We need to know who said what, whether it was JT or DO. Which person said what?
I get the whole victim's rights and Marcy's law, but we don't have to use initials. This is a formal hearing. Please use the names. All right, so that is sustained.
Who did you talk to?
We talked to Jack Taylor and Desiree Otto.
Did any of them say how the circumstances led up to the attack?
Yes.
Who and what did they say?
They both said that.
That's the form. There has to be a specific identifying who's speaking.
That's why I said who and what did they say?
And that's a compound
The
question.
compound question sustained.
Who did you talk? Okay. What did Desiree say?
Desiree said she was in her bedroom and the two suspects entered the house, went down to the bedroom, entered the bedroom and attacked her and Jack.
What did Jack say?
He said that he was in the bedroom and they came in and attacked him in the bedroom.
Did Desiree give any more details about how the attack went?
At that time, she said that later on, she did give more details. Do you want me to go into what was said later on?
Yes.
Okay. Yeah, she said that when they entered the room, that she was grabbed by her hair, this would have been by Rhea, and then shoved to the ground and then kicked on the side and the head approximately 20 times. And when she was grabbed by her hair, it ripped some of her hair out.
And did she say where this occurred in the house?
It occurred in her bedroom in the basement.
Okay. Same question for Mr. Taylor. Did he give further explanation of the circumstances of him being attacked?
He did. He did not know the suspects at the time. He said that one female entered and attacked him. And he said that the other one began attacking Desiree.
Okay. Were there any recordings of the incident that you reviewed?
Yes, there was. Lisa, the homeowner, Desiree had called Lisa and left a voicemail. And in that voicemail, you could hear female, presumed to be Desiree, screaming. You could hear and you could hear a voice, female voice saying, "Go, Rhea, for your grandpa," and saying "go" multiple times.
Was there any explanation given of what the connection of Alicia Roseland and Rhea Shabash was to this residence of the people there?
Yeah, so Rhea was a foster child of the owner of the house. She had been there approximately, I believe it was till she was 6 years old.
That was quite a long time ago.
Yes.
And did the owner of the house indicate whether they had permission to come in?
Yes, she said they had no right to be there.
Okay. Did you talk at all to either Rhea or Alicia?
Yes.
What did Rhea say about the incident?
Rhea said that there was a conflict at a bar in town. She said that she had went to the house to confront Desiree. She said that Rhea said that it was her grandpa's house. So she entered the house, went downstairs to the basement. She said that they met her by the bathroom, Desiree, and then she did not know what happened after that. It moved to the bedroom and she did not know.
What did Alicia say?
Alicia said that she said that it was Rhea's house, and that I'd have to reference the report to see exactly what she had said for entering the house.
Refresh your recollection if you reviewed the criminal complaint.
Yeah. Okay. So with
Objection, I want to know what page
okay,
he reviewed first, Judge, and then not to read the page, but what did he review?
What pages have you reviewed, or did you review the entire criminal complaint?
I reviewed pages 1 through 4 up to 4 of 8 to read.
Please put the document down or
okay.
give it back to Mr. Schmidt, and then
Okay.
he may answer the question.
So specifically, Alicia, when asked what had happened, she kind of chuckled, looked at Rhea and said, "How do I explain this?" Or "How do we explain this?"
Is that all she ever said?
She mentioned that it was Rhea's house and that's why they went there.
Okay. Did you ask either I guess you said the flame, either Jack or Desiree if the attack caused them injury? or
Yes,
Payne?
yes,
What'd they say?
yes, they both confirmed that it did. Talked to Jack later, and he confirmed that it did. I reviewed body camera and observed Desiree had wincing in pain when her head was touched. And then she said she did have EMS, she did get looked at by EMS at that time.
Were there visible injury to her?
Yeah, she had a small cut on the back of her head, blood behind her ear, and she said she could taste blood.
Did she indicate whether she gave consent to being attacked?
She said she did not.
How about the same question for Jack?
Yeah, he said he did not.
When Rhea was explaining that she went over there about something at the Pheasant Inn, was she saying that happened the same day?
Yes, yeah, she said it was approximately 10 minutes earlier.
Okay. I don't recall if I asked this, so if I'm repeating it, just let me know. You identified who the homeowner was?
Yes.
Who was that?
Lisa?
And did
Taylor.
she say whether Rhea and Alicia had permission to enter the residence?
Yes, she said they had no right to be there.
Okay. Did she know Alicia at all?
She knew Rhea through being a foster. I could not recall if she knew Alicia.
And just for clarity, when Desiree was explaining who was attacking her, did she say it was only Rhea or only Alicia or something else?
She said that they had both entered the room and attacked her. Later, she said that it was Rhea that was the one that had pulled her hair down. And she said that Alicia had attacked Jack at that time.
Okay. I have no other questions.
Mr. Harrington.
Thank you, Judge. Did you check the public record to see who actually has title to the real property?
I asked the
Did you
homeowner.
check the
No,
public
I did
record?
not.
There is nothing in your reports or the criminal complaint that indicates that Alicia pulled Desiree's hair, is there?
No.
There's nothing in the criminal complaint to suggest that Desiree kicked, that Alicia kicked Desiree either, is there?
Not in the, no.
And the source for the information that Alicia attacked Jack comes from Jack, correct?
Yes.
Alicia told you that Jack struck her first. Did she not?
I do not recall her telling me that Jack punched her first.
Okay. But you don't recall that.
There-
That's not in the complaint either, is it?
Mhm. No, it's not in the complaint.
Have you talked to, no, I'll withdraw that. Do you know what the disagreement between Alicia and, strike that. Do you know what the disagreement between Rhea and Desiree was about, other than some family thing?
I do not know the specifics. I know that Rhea or Alicia at the time had said that Desiree had said something to her at the bar, called her name.
Thanks. I have no further questions.
Questions, redirect?
No redirect.
You may step down. Thank you, sir.
Move to dismiss, Judge. There's no, are you done, Kevin? I'm sorry. I jumped the gun here.
Further witnesses?
No other witnesses.
I'll move to dismiss. There's no evidence that they entered this premises without the lawful consent of the owner. Because someone self-represents that they own the property, isn't conclusive as a matter of law as to who actually does. Further, there's no evidence that Alicia kicked or stomped or did anything vis-a-vis Desiree or Jack. Jack has an interest in this, and he self-reported that Alicia punched him, and there's no other evidence in the preliminary exam to suggest that that's an accurate recitation of the facts. State has failed in its burden. Move to dismiss.
Mr. Schmidt.
I think we showed the lawful possession with all reasonable inferences drawn in favor of the state. What needs to be shown for burglary is not title ownership, it's lawful possession. And we've definitely shown that here with the statement from the woman that she's been there for over a decade because she knew Rhea because Rhea lived there as her foster child in 2006, I believe, is what the officer testified to. So she plainly had lawful possession and plainly said these people didn't have consent. In fact, what was described is that a person named Desiree insulted Rhea Shabash, and then Rhea Shabash and her friend went to the house to seek her out to make good on that on their own. I'd also know everything that Attorney Harrington said about who did a battery or not is irrelevant because that's not one of the elements of this offense. The element of burglary with intent to commit battery is whether you have the intent to do it. If a battery actually happens, that's just an enhancer. So I think all reasonable inferences draw in favor of the state. I think one can conclude that these two people, after seeing this insult at a bar, went across the street, went to this house for the purpose of settling up. And even if Mr. Harrington wants to discount that the officer did testify that Desiree said both of them attacked her, which the court should not, this is party to a crime liability that's shown with like the voicemail showing only other person there who was supportive of Rhea attacking this person could have been Alicia Roseland. That's also reasonable inferences. So I'd ask the court to bind over.
Judge, one comment.
Rebuttal, yes.
There's no identification that the person overheard on the telephone cheerleading, in essence, is actually Alicia.
That's why I said it's a
And secondly, Judge, the defendant's not charged with party to the crime. She's charged with actually committing the act. I'll concede that can be solved quickly with the information.
And it can be, and I understand your argument and where you're going, Mr. Harrington. And this is a preliminary hearing and the court has to determine whether there's probable cause to have a felony charged. Defenses are not something that the court can take into play in a preliminary hearing. I can't make any determination of truthfulness of anyone's statements. I can't go to credibility. I can't view the evidence like a jury would. I have to take the statements and the evidence as presented, and it was presented through the testimony of the officer. Cases that have conflicting inferences means the state wins, and there's enough to at least bind it over where a reasonable officer here in training and he reasonably believed that a felony was probably committed and therefore it was charged. In viewing the evidence in the light most favorable to the state, bound over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set for another date, Mr. Harrington.
Can we set this for another day simply because it's a technical defect, but I think it has to be charged as a party to the crime. And if Mr. Schmidt is charging these as pled in the information in the complaint, I want to have an opportunity to look at that before I have my client plead. So
Yes, I understand.
another
that.
day, please.
Mr.
Two
Schmidt.
things I'd say to that is if you look at the annotated statute for party to a crime, it says it does not need to be alleged. Also, by having the prelim, you waived any arguments against structural defects.
But here's the thing, this is a discussion that attorneys can have outside of the presence of the courtroom. Therefore, I'm going to set it for another date. You can figure it out. Does May 28th at 9:15 work?
Judge,
Oh, you're fishing.
I'm fishing
Don.
in Canada. I'm sorry. How
Nope,
about
that was my mistake thinking you're only going for a day.
How about June 9th, July 9th at, that 10:30, that'll,
Nope, that's way too far. I can do 6/1, June 1st.
I'll
at
be here on
1:45.
another case on June 1st, that'll work.
What time are you here? I didn't look. I don't know what time you're here, but we can figure that.
Mr. Harmon's bail hearing, I think that's it. I left the notice in the truck.
Oh, you are here at 1:30. So June 1st at 1:30, we'll have an arraignment. We can preset that other July date for a status if that's what you would like.
That makes sense, Judge.
Let's preset a status for July 9th at 10:30. July 9th at 10:30. Arraignment will be June 1st.
1:30.
We set a status and an arraignment?
Yeah, just to keep them on the same path, the co-defendants. All right, Ms. Rosen, you can come up here and get your notice and you're free to go. Thank you. Mr. Ramstrom?
Yes.
All right, we will go on the record in the matter 26 CM 28, 26 CM 29, State of Wisconsin versus Matthew Ramstrom. The state appears through District Attorney Kevin Schmidt in person. Mr. Ramstrom appears by telephone conference with approval of the court. We're set today for a status conference. Mr. Ramstrom participated in and completed a domestic violence course through an online course. The offer was to have him do the Dave Hatch Restorative Justice course and plead to an ordinance violation. Mr. Ramstrom, were you able to complete that program?
I thought it was like the, whatever you sent me on, I Googled it and I did the one.
Again, we went over this at the last hearing. We went over this at the last hearing, that was what the court ordered on your bail bond. But that is not the offer from the state. But I do have
now you want me to meet with a guy, with some fella?
That's Mr. Schmidt.
Okay.
No, Mr. Schmidt is looking at the case. He's the district attorney. He has final say in the cases. This is an actual ADA case, but the ADA is off today.
Because that course definitely covered a range of things.
It's not for you to negotiate with the court. It's not then negotiate with the court thing. It's a negotiate with the district attorney.
I see that my assistant reviewed what he did online. He did think it should satisfy it. So my indication here is because he did that, the offer would be DC for costs only.
So plead to a disorderly conduct,
Yes,
not an ordinance, the misdemeanor.
that's what his notes seem to indicate.
All right, so he will accept that course that you did, and the offer is plead to a disorderly conduct without any domestic abuse attached for costs only. Are you accepting that offer, Mr. Ramstrom?
What does that mean? That I still pay a fine?
Yeah, it would be a fine, a court fine for the case.
Yeah, like we were talking before.
Correct.
Okay. And then it's just closed and
Then it's
done with?
closed and done.
Okay, yeah, because this has been exhausting.
All right, so you are appearing by telephone conference. Do you understand you have the right to be here in person?
Yes, Your Honor.
And do you wish to settle this matter and take a plea and be sentenced by telephone conference?
Am I looking at like jail time or something?
The offer is for just the fine.
Okay. Like no probation or jail and nothing like that?
Well, that's what the offer is from the state. Yes, to plead to a disorderly conduct for a fine only.
Okay, what is like I don't get it. Like you're trying to put me in jail?
Mr. Ramstrom, the offer from the state is plead to a disorderly conduct. They're going to recommend to the court that it's only a fine. Yes, the court could, if I thought that this was serious, if I thought that this was cray serious, and that you should be punished more, I could, as a judge, punish you more, and I could, as a judge, sentence you to 90 days of jail. However, the recommendation from the state, because you did that program and it exceeded what they were expecting, is for costs of fine only.
Okay.
So do you wish to
Just the
accept
court
that
cost.
offer?
Yes.
All right, and you're pleading and being sentenced by telephone. Do you wish to continue today by telephone, or do you want to set it up for an in-person date?
For what?
To
For
be,
payment?
no, to be here. Sir, for court.
Okay.
I need to know if you want to take care of this today by telephone, or if you want to say, you know what, Judge, I'd rather be there in person and I'd rather look at you in the face when I get told what a disorderly conduct is and what all the things mean. I'd rather be in person. Do you want to be in person or by telephone?
Isn't it just a misdemeanor?
Yes, it sure
Like a
is.
misdemeanor?
It
Yeah.
is surely duty, highly lily. A misdemeanor.
Well,
It's what I have to do, sir. I have courts that say that there are certain things that I have to do on my job, on the
Okay.
record. That's one of the things I have to ask you. Do you want to do it by telephone or do you want to be here in person?
no, Your Honor. I'm fine doing it by telephone.
Excellent. Formal motion to remove domestic abuse enhancer.
So made.
Granted. So, Mr. Ramstrom, how old are you?
40?
Can you read, write? You understand the English language?
Yes, ma'am.
Any drugs, alcohol, medications, or mental illnesses or disorders?
No.
Do you understand you would have the right to go to trial? You would have the right to an attorney. You would have the right to have yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have a right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of that?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around February 7th, 2026 in Burnett County, Wisconsin, in a private place, you engaged in abusive or otherwise disorderly conduct, which tended to provoke a disturbance. That is a misdemeanor. Maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both. Do you understand that charge and what the maximum penalty could be?
What it could be, but we've already negotiated what the penalty is, right?
Again, I can do what I want. I'm the judge, but that is the
Well, then
recommendation.
maybe I will
So,
take this to trial. I don't know why. I don't know why you can't.
sir, I just
agree on
have to do my
something.
job, sir. And the law
Okay.
makes me say all these things on the record, sir.
Okay. Yes, I understand.
All right, that could be a maximum possible penalty. The recommendation again from the state is a fine and costs only. So you understand that if I thought that this was outrageous and very abusive and very violent and very harassing, I could sentence you up to 90 days.
I understand, Your Honor.
All right, okay. Now, are you admitting here today that your behavior that day would meet the definition of the disorderly conduct under Wisconsin law?
Not at all.
You don't think you were
Maybe-
disorderly or
maybe
you
my
provoked a
language
disturbance?
After the
Oh my
fact,
God, you
but,
are awful.
um,
You're coming here in person and we're gonna do this in person. I can't do it because A, you want to talk over me all the time. B, I can't look at your eyes and say, shut up. C, you're not understanding anything.
No, I understand fully. Like, I was out of line.
You were out of line. And what I'm asking
Oh,
you,
I was
the
not supposed to
definition,
be having contact.
the definition I gave you for disorderly conduct, your conduct that day was otherwise disorderly and it provoked a disturbance, correct?
Correct.
So you're pleading guilty to the disorderly conduct because you're guilty of that conduct, correct?
Correct.
All right. Has anyone threatened you or promised you anything for you to plead guilty today?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing.
Yes, ma'am.
and voluntarily?
Yep.
Do you have any questions for the court or for Mr. Schmidt, the district attorney, before I proceed?
No, Your Honor.
As to count 2, disorderly conduct without an enhancer, how do you wish to plead?
As guilty, I guess.
Are you guessing it or do you know it?
Yeah,
You're pleading guilty?
correct.
All right, the court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of disorderly conduct. The remaining charges and the other case will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
This is minor behavior around an injunction that has since been dismissed. This is appropriate. I'd ask that you follow.
Mr. Ramstrom, what do you want the court to know? Anything? You can make a statement.
No, Your Honor.
All right.
Just like this all to be over with so I can go on with my life.
I understand the facts of this case. I understand the facts of you and your ex, or the mother of your children. I understand the situation. It is not, does not rise to an entirely serious level. You are admitting responsibility and being accountable and pleading guilty to a disorderly conduct. So I do think that it's appropriate. I don't think you're a risk to the community. Therefore, the court will follow the recommendation, $500 cash. You have that posted. You are good to go. No further money is owed to the court. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You need to call the sheriff's department and see if they have it. If they do, you're good to go. If not, they'll just come in and request that you provide a swab of your DNA. But in a case like this, you do have the ability to request it be expunged from the CODIS system through a written letter to the Department of Justice, the Wisconsin Department of Justice, not to the court. All right, anything else?
All right.
Not from me.
Nope, I understand that.
There's nothing further than we are adjourned. Mr. Locke, is that you on the Samsung? You are muted and I hit a button to ask you to unmute and I'm now hit something to ask you to start your video. There you are. How are you doing today? Are you Mr. Locke? I don't know what's going on. I should be in there. I will hit a button again to ask you to unmute. There.
There we go. All right.
Are you Mr. Locke? Are you Ryan? Because I'm going to tell you, I need to understand who you are, because when I saw you at the last hearing, you were in custody and you were really, really tiny. So I need to be able to know so I can put your picture of your face in my head to associate things. So I am speaking with Ryan Locke.
Object.
Sir, well, if this is the route it's gonna go, and I think I've been very super fair to you and with your bail and with all of those other things, if this is how it's going to go, then I will never allow you to be by Zoom again, and we can get a warrant and we can go that route. So if you want to cooperate and you want to participate and be nice to me as I am nice and respectful to you, we can go about it that way. How would you like to go about it?
I am trying to speak and you are.
All right, so here's the thing. Nope, I'm letting you speak, and you want to speak and tell me all about your contract and how you're going to hold me responsible.
I'm not contracting anybody. I'm not saying any of that.
Well,
I'm just trying to speak my
so then tell me,
constitutional rights. That's it.
On your birth certificate, did your parents name you Ryan Locke? Yes or no? And I did grant you leniency, Mr. Locke, to appear by video. I have every right to never allow that to happen, ever. You understand that? Yes or no?
I'm asking you, can I ask you a question?
Nope,
Yes or
not
no?
unless you answer my question. Do you understand what I said? Yes or no?
I object, and it sounds like the court is trying to get me into their
All right,
jurisdiction.
we will go on the
Is this
record in
court
the
in
matter
of record?
26 CF
Is this court of
46,
record?
26 TR 306, State of Wisconsin versus
I
Ryan Locke.
object.
The state appears through District Attorney Kevin Schmidt in person. We have Emma Hanu appearing in person. Ryan Locke appears by video conferencing. He did call and ask permission of the court. He was being a cooperating individual and human being. However, he is failing to cooperate here today. Therefore, the court is stating on the record, at no time in the future, at any time whatsoever, Mr. Locke, may you appear by video conferencing or telephone. Your hearings will always be in person hearings. With regards to today, the court will quash the warrant. I don't have to do that, but I'll be nice and I'll quash the warrant. I'm resetting it to another date and time. Ms. Hanu has asked to withdraw. I usually ask for information and go into it. I'm not going to today, Ms. Hanu. You may be withdrawn. The court is going to reset this to another date and time. You were legally served. I have all of that information, so I do know that because you were in my custody and the court did give you leniency, did modify your bond, was trying to work with you, Mr. Locke. However, you refused to work with the court, and the court finds that to be completely disrespectful. Therefore, I am setting this for another date and time. Mr. Schmidt, is this a your case or a Filet case?
It is Assistant District Attorney Billard, Your Honor.
That's correct.
All right, so what I'm going to do here today is I am resetting it for May 27th in person at 2:45. May 27th, 2:45. We shall see you then. I strongly recommend that you call the public defender's office
muting me.
and you
Why
get
are you
another
muting-
attorney appointed to you. I'm resetting it. Thank
Can I
you very
speak,
much.
please?
We are adjourned.
Object.
Bye.
Bye. That just happened. Oh yes, that just happened. Bye. Can we get a bye in chat, ladies and gentlemen? You know when I saw that happen, and immediately in my head I was like, that's how we're ending it tonight. That Mogan, every time she does that, she sounds like one of my cousins. She does that same type of thing. Bye. It's so funny. Oh my dear God. Ladies and gentlemen, it got out of control. I mean, what happened? By the way, Rhonda, thank you for that link. We are redirecting over to Hutch right after this. Very soon. He's doing a little premiere. YouTube's been giving him a headache. He finally got a link for me. I got that redirect put in place. Hang out, ladies and gentlemen, for another sovereign crazy story. You know where there's one. I mean, you can't stop crazy. That's the real lesson with all of these sovereign idiots. You just can't stop crazy. Crazy will always be really crazy. Ladies and gentlemen, I just don't even want to say about all these cases tonight. It was a mess. It was all a mess. And people just kept putting their feet in their mouth, one after the other. I mean, from Hesselink all the way through with Judge Dad, Judge Simpson, for God's sake. I had all those. It never stops with these guys, right? And poor Judge Mogan, she was not in the mood today. Not in the mood to put up with it at all. Ain't nobody gonna roll over her. But speaking of rolling, ladies and gentlemen, get those credits rolling, shall we? Hey, good, all these wonderful people here. Mud right at the very top, Rhonda, Kiernoth, and Julie Sassy. I want to thank you all for hanging out tonight. Thank you, everybody, especially Hutch out there in the chat. Sovereign Legal Encounters United. I can never remember the right name. He's Hutch. Divine Mystic Whispers. Julie Sassy, Kimby Mom, Becky D, Allie B from Tennessee, Karen Noth, Olive Cat. Bye! Thank you all very much for coming by tonight. We do this every single night of the week. And hey, there's one more night to go. And we'll probably have a break of some sort on Monday. I don't know. I'll probably have some stuff I can show. I did not mean to rhyme. That was kind of a weird time. Oh, I can't stop now. Okay. We're ending this thing. My name is Lone Wolf Usul. I am your host for these here little get-togethers. I am your curator for this crazy channel. And I am out. Bye. Is it Thursday yet? Oh, it is. Get out of here. I don't have anything else. Go away. Bye. Go watch Hutch. Good show. Great. Thank you for all hanging out. You all rock. I love you all. Bye.